Welcome to this special episode of Put Simply, the third in a four-part series examining the Express Pearl incident, ship that sank off the coast of Sri Lanka and triggered an environmental disaster the island may be living with for decades. I'm Erdem Koch, and in the first two episodes, we explored the political context surrounding the Express Pearl, where things stand today, and the scale of the environmental damage left behind. Today we turn to the most complex chapter yet, the tangled web of legal proceedings that have since been unfolding. I'm joined as always by my co-hosts Rodney McCune and Ozan Ibrisim. Gents, wonderful to see you both.
Good to be with you.
Good to be with you guys.
So Rodney, we're going to ask you to put on both your legal hat and your observer hat and try to explain to us to the best that you can this really complex picture that is the legal proceedings related to the Express Pearl incident.
So I'm going to don my Put Simply hat and hope not to get criticism from other lawyers by oversimplifying matters. But there are proceedings in three different jurisdictions, in Sri Lanka, in Singapore, and in London in the UK. And those are the legal proceedings associated with this case. The claim in Sri Lanka is the one that culminated in the initial $1 billion compensation order by the Supreme Court, which was based on the flawed environmental evidence that we discussed last week. And it is moving to a phase where there is a committee established under that court order and a commission to further assess more future or ongoing damage. Again, very odd for legal proceedings or legal ruling, because it's not something that reaches a finite conclusion, but we'll come back to that. At some point, the Sri Lankan Attorney General, previous government, not the current government, commenced proceedings in Singapore against the ship operators, and did so through a Australian law firm where some $4-5 million was paid up front for initial advice and to sort of first steps in a claim. And there's some dispute about whether or not they advised to initiate proceedings in Singapore, or it was something that was always intended by the Attorney General. It's complicated further because the Environment Agency had got legal advice, which I suspect, or I understand, was shared with the Attorney General not to commence proceedings in Singapore, but he did it anyway. And it was advice that was referenced in the Supreme Court judgment, where they looked into the Attorney General's strategic decision-making. Those proceedings then were moved to the International Commercial Court, which is a big hub for this type of litigation in Singapore, where it's seen as trusted and respected. Those proceedings, according to the current Attorney General, are on pause and haven't really made a great deal of progress. The third set of proceedings relate to something called a liability cap, which was imposed, triggered by the Singapore proceedings imposed by the Admiralty Court in London, which in effect places a ceiling of 20 million compensation US on the point of liability, unless, and the time when under international law that would be a departure from that is if there was some malice. So I took my own ship to your back garden, Ozan, and sank it. Well, then maybe I would be on the hook for more than what the cap or the liability ceiling put in place. But in relation to this incident, of course, nobody at any stage has or I suspect would suggest that, for obvious reasons, that it's not supported by any evidence. This was strict liability ruling in Colombo. There's no suggestion, and never has been, of some sort of malicious intent. So yes, London we can park because it sort of limits what's happening in Singapore, which is on pause. which takes us back to Sri Lanka, where on the basis of the flawed environmental assessment, we had this huge award. It was a claim for 6 billion US dollars, of which 1 billion was awarded as an interim payment. With further investigations and so on to be done, and that was part of the direction of the Supreme Court in Sri Lanka. Um, but yeah, and the way it started and how it proceeded as a UK lawyer, albeit not within the maritime sector, it's just very odd. Very odd.
You mentioned that you might cop some criticism from those in the legal community. I think I'm going to get a lot of criticism, considering I'm the only non-lawyer on
Yeah.
in. So I'm going to really simplify it and try and unpack it, fellow non-lawyers like me. But if I understand correctly, the 1 billion was kind of awarded as damages. It hasn't been paid by the company, but from what I can gather, considering that there is a $20 million cap on damages, from what I can gather, the company has actually paid in excess of that, whilst not $1 billion, but they have paid some damages. So this court case effectively came after those damages had been paid, and it was almost another grab for more money from the shipping company.
Yeah, well, the insurers pick up the payments in something like this.
Yeah.
But there's a separate bill for the salvage and removal of the wreck of the vessel, which included ocean and beach cleaning and so on. So the total spent is something upwards of 160 million, on a number of aspects of, let's call it the response, areas of compensation and so on. But
And
if you remember from last week, the compensation to the fishermen, which
yes.
was for, the inability to fish for a period of time and so on, is not the substantial part of this 6 billion. 4.5 billion was marked against the loss of tourism because of a loss of a number of turtles, and you'll remember that some of those were said to have been hit by an oar, and the causation
Yes.
wasn't clear in terms of. So that was last week's discussion. So even though there's this potential, cap issue and so on, that would have absorbed and covered the compensation on fishing in those other areas within that sum of money anyway. These huge additional heads of claim, like in relation to turtles, or the oil spill that was said to dissipate naturally, or the nitrogen that, they didn't actually find the evidence of this reaction and so on. Those are all the additional things which start driving, what could be a few tens of millions into hundreds of millions and then billions in terms of what's being claimed. So I think you're right to point out the cap, but I also and the fact that it's been exceeded, but I also think the discussion around that only becomes relevant if you've got a robust scientific basis and economic assessment following the scientific analysis, which gives you figures then that are above or substantially above a cap that's in place. Where I think in a lot of the discussion around this is the cap against the figure that doesn't really stand up. And actually, unless you get to the point where you've got a credible figure and a cap, and if there is a disparity, then maybe that's something you know that you would discuss at the time. But it feels like there's very different conversations happening around this particular case. A drive to remove a cap that wouldn't that would that would be removed in order to substantiate a figure which isn't substantiated, I guess, is the way I look at it after
And
last week's discussion.
no, I mean that was very clear. That last week's discussion certainly illustrated a report that had quite a number of holes in it, and I guess the credibility of that report could be rightfully questioned in terms of the money that was spent by the company to do the salvaging you mentioned, but also the cleanup. Is that being factored into the damages? Because at the end of the day, again, I'm not an environmental expert nor a legal expert, but I would suspect that a lot of that cleanup would then contribute to a lot of the damages that are being asked for. would kind of in some ways negate that. Would that be a very simplistic, non-legal kind of understanding of it?
It would make sense, Suzanne, but it's not in this case. In this particular case, the direction for 1 billion is on top of what has already been paid, is my understanding. And as I said, again, like normal proceedings where you predict future loss, you assess current loss, and you come up with a point of closure where you have a fixed number that is what's awarded as quantum or damages. This is open-ended, and the court's directed that they set up a commission to look again, and it feels like the difference between a la carte and buffet, where it feels like the Sri Lankan proceedings are that you can just keep going up with your plate until you can no more, and irrespective of how much you've ate or whether that's satisfied your appetite at that particular point. And it's a very, very odd proceeding to find yourself in a position where instead of saying it's going to cost me, I've had a house fire, I want compensation for stress and loss of goods and the cost to rebuild my home and so on. But on the Sri Lankan model, I also want some compensation in case I decide to add an extension in a couple of years' time to make the garden look a bit better. Or, if I decide to have another kid and maybe I want to partition a room upstairs, maybe I should get some money for that too. Or, instead of giving me it now, maybe we'll just come back when I decide to do that and I can take another bite and another bite and another bite. And that's a bit which, in terms of the court orders, are definitely quite odd. The other thing of course, they ordered was statutory breaches on behalf of the chair of the Environmental Protection Authority, statutory breaches by the Attorney General, criticism of the legal strategy. They actually directed that the Attorney General be investigated by a police or a corruption investigation on the decision to launch the other proceedings. So that's something which is in the ether, and I don't know whether that's actually been actioned, but it was something that the Supreme Court recommended in July of this year. But all those statutory breaches, how much in compensation or damages did they have to pay? Bearing in mind it included failure to respond adequately to the incident, failure to set up certain emergency committees to respond to the incident. How much have they had to pay? Guess, guys.
Not much.
Zero. And all the damages or compensation has been set against the operator or the insurance company or whatever, that side of things, which is pretty much fascinating. You could take the view that in government, if you're ordering compensation against government, you're moving from one pocket to the other. And it serves no purpose. But sometimes a direction of the value of your failings, or the cost of your failings, in this case with the government, at least marks the fact that it hasn't been as good as it could or should have been, right? And it didn't happen here. But then the proceedings themselves, Ozan, when you look at them, and Erdem, you'll know this as well, very well, that when you go to something that involves a public inquiry, you have a certain format. Where it feels like it's more judicial led, but there's still the calling of live evidence, the cross-examination of witnesses to establish the fact. If you have something which is a more adversarial system, you'll still have the calling of live witnesses, the cross-examination to check the accuracy. So you form a factual basis on which you then apply law to reach decisions and judgments. None of that really happened here. There wasn't live evidence. There was some documentary evidence submitted where there was gaps. It just feels like it was cherry picked a little bit, or it reads like it was cherry picked, reading the rather long judgment, not necessarily with a clear basis for why some parts were preferred to others. The only expert evidence to substantiate the claim came from the Maritime or the Marine Environment Protection Agency, who were themselves the respondent in the case, not the claimant. So the claimant relied on the respondent's expert report to make a finding of a monetary sum of 1 billion, potentially 6 billion, attached to another respondent. So that in itself is incredibly odd. And that's the same respondent who was found to be in breach of their statutory duties and failing to respond professionally to the incident, but professional enough to come up with what we now know is the discredited environmental assessment, with this sort of large figure attached. So even those aspects, and I think we referenced previously that there was a shipping operators report that was in the ether as well, that the Supreme Court decided not to allow to be part of it, despite it undermining the environmental assessment. And one of their points was to say that all it does is criticise the failings of the assessment we have, not offer what they think the figure should be. In an adversarial system, he who asserts must prove, right? And that seems to be not an unreasonable way to approach these proceedings. But with this particular set of proceedings, that wasn't the case. And when you roll it back to where it all started because um, fishing communities brought proceedings against the government because of the non-payment to the fishing communities of money that had been paid to the government on behalf of either the insurers or the operator, but externally to be distributed to those people as beneficiaries. So I don't know whether it's the same in Australia, but it seems to have started out more like a judicial review proceeding where you're trying to force government to do something, in this case, distribute money. And then over these sort of period of merging cases and so on, it then turned into this rights petition, which ended up at the Supreme Court, not because it was on appeal from a lower court, because it started in the Supreme Court, in effect, the hearing or the trial or the evidence or the assessment of documents in this case, which again feels really, really strange. You look at the US or you look at the UK, you end up in the Supreme Court because you appeal on a point of law, on a case that's already been decided somewhere else, where there has been an interrogation of the factual basis. There's been a consideration of what evidence can and cannot be included. And, there's a right of appeal. I don't even know, with this case starting in the Supreme Court, who the appeal is to if you're not happy with how they've applied the law. And it's also very emotive language in terms of the judgment as well, which I find quite interesting. It just sits as someone who, I haven't practiced for a decade now, but I still remember many trials that I was involved in. And I've been, before the Court of Appeal in the UK and, other senior courts. It felt odd as the form of the judgment as well. The weird way that it seemed to conflate adjudication, fact finding, investigation, direction, even some of the stuff around what it directed about the Attorney General. It nearly concluded that the Attorney General's office at the time did something wrong, and therefore should be investigated and punished by these other statutory agencies, rather than it's something to look into. It's quite different to what I guess I would have expected with my own sort of external lens and perspective. But there you go. You learn something, and perhaps it's odd in the Sri Lankan context as well. What I don't have, a little bit like the scientists who come up with the environmental assessment, is a baseline in order to say whether this is odd but normal within Sri Lanka, or it's odd and even in Sri Lanka it would stand out as odd too.
So I guess it kind of begs the question then, Rod, where do things stand today, and where do things go, more importantly, to come to some sort of resolution here?
Yeah, it just feels like you've got problem with the environmental assessment on which a decision which is significant was based. You've got I guess, an opportunity with a new incoming government, or a government that's been in a relatively short period of time, to unpick this and, at least in the process of untangling it, and acknowledge that many of the decisions that led to this point were taken during the previous administration. But that has to be an appetite to do that. And it feels like it's run into the ground to an extent where you have proceedings that can't be enforced, in effect. You have probably some issues around non-compliance with a judgment potentially being a contempt of court. That'll no doubt be something that'll be considered at some point. You have these proceedings which are paused in Singapore pending an attempt to remove the cap in London, which is, I suspect, unlikely to succeed given the whole point of malice and so on. And you seem to have, I don't know whether there's an appetite to review this whole thing again, but I guess if we all put having been involved in politics our political hat on again, political hats on rather than a sort of a, I was going to say a legal hat, but obviously I meant my wig and gown, a political hat, what would I do? I guess I would probably, at least with this commissioner committee, to look at further levels of compensation, would to try and inject a level of critical and credible environmental assessment into the process through it, and maybe create a bit of an off-ramp there where there is a review by scientists of how they got to whatever figures and potentially a closed end of the process and a revision of figures based on, more robust scientific analysis. But I don't really know whether there's an appetite to do that. For me, I mean, that's one option. The other option is for the government to step in and take a proper, robust view of the Environment Protection Agency, its capacity at the time, which was said to be below employee numbers, below ability to carry out statutory duties, and also operating in a difficult climate at the time, because you've got to remember it was during COVID, and that was relevant to both ambient pollution levels, which were lower than normal, which meant that any impact from some aspects of the incident didn't elevate things before what was within the normal bracket. But also it stretched governments across the world, with fear of health services collapsing and so on. So, you can maybe say that, that put challenges there, but if your government fails and fails to respond to an incident through an agency, and you find them to be in breach of their legal responsibilities to citizens, and you don't do anything about it and just sort of remove the head and hope it'll get better, yeah, I guess that's a big gap here. But maybe there's a fear that in doing that, that there's a that there's some acknowledgement of shared responsibility, and maybe that's what they're trying to avoid because they want the bill to be picked up by someone else. And that's all very depressing, to be honest. In the same way that we talked about, when you have an environmental assessment, it feels a little bit like the little boy who cried wolf, that people find out was wrong. Well, they start to say, well, what else are you wrong about? What else are you cutting corners about? And there's going to be a bit of that, I fear, for a national reputation on the integrity of legal proceedings potentially further down the line. If you have judicial processes that sort of operate in a way that feels quite alien, that doesn't allow you to present your case in a way that maybe you feel is right on sort of an equality of arms, or I'm going to say the UK or the traditional Commonwealth basis, then you sort of question the value of the whole system, the trustworthiness, and so on. Is it somewhere you want to invest? Is it somewhere that you want to do business? There's broader considerations and all these things. Yeah, damage can be done, unfortunately, to a country's reputation. In fact, it's what many of the countries in the Middle East, where they're trying to get a share of arbitration and other, types of dispute resolution business, which often has been dealt with in places like Singapore and London and so on, that they've worked very hard to create a level of trust for investors, for business, so that they can say, well, look, even if there is something that's a bit of a dispute or there is a divergence of opinion, it'll be resolved by a fair and proper tribunal. And the last thing you want to do when you're trying to, attract investment where the economy's been on its knees, as it has been in recent years in Sri Lanka when, things really got bad, um, is to then, you know, damage an investor or business confidence in your region or your country. What do you think, Ozan?
I think all very valid points. I think when you dig deeper and deeper into this story, it becomes so much more fascinating, and in a lot of ways concerning as well. Because in a very simple kind of context, what we've got is a shipping line who, again, this is from the first episode, who noticed, and came to be aware of a significant leak. that leak meant that they were seeking kind of safe harbor, I guess, in a number of different countries, to the point where it came to Colombo in Sri Lanka, off the coast of Sri Lanka. Things got very bad. They tried to do everything, from what I could read, in the right way and follow the processes, etc. Now, they were let down by a number of governments, but then it came to a head with the ship going on fire, and causing environmental damage off the coast of Sri Lanka. Then you have a situation where the shipping company seems like they've done the right thing by cleaning it up, putting some compensation in place. The insurance companies will come in, etc. And then you've got a government on top of that saying, I want, some sort of ambit claim saying this is going to, based on, as we discussed in the previous episode, very small amounts of evidence, or very kind of questionable evidence, saying I want $1 billion compensation as part of a bigger package of compensation. As much as we on this episode, so on this podcast, would be shocked if the shipping company didn't have some sort of responsibility to do what they've got to do to clean it up and what have you. But it is odd to me that, and we raised this on the first episode, no government is, or it's a very grey line when these sorts of things happen about governments stepping in to help resolve it. But it also seems very odd to me that a private company then has very little legal recourse to sue that government for their negligence in having or playing a role or part in making this kind of environmental damage. Because let's face it, as much as the company should be held liable, in this case the government should be. But that's the way that I see it from a very non-legalistic point of view. But on top of that, then you've got the government going in and going to make a bigger kind of cash grab. This is really fascinating, and I think it calls into question a lot of things about maritime law, but generally, I think legally as well. How do governments expect to be taken seriously when such poor process, from what we can gather, has been followed to come up with these sorts of things?
Indeed, and I think it's one of those things that's you could probably spend hours trying to decode this very complex set of legal proceedings, but you've both done a fantastic job in putting it as simply as possible. Well, the next episode wraps up this special 4-part series, and we'll look at the economic impacts, to the best of our ability, of this disaster on Sri Lanka, on the region, and any other implications that might come up as well. Gents, thank you so much for your time this week. See you both next.
Thanks a lot, guys.
Thank you.